Hello, welcome once again. Employment Law Show. So good for you to hang with us for the next half hour. John Scholes here beside me, Lior Samfiru. I'll give you some reach out, some contact information right off the top, but we'll have it right along the bottom of the screen. During the next half hour, 1-855-821-5900, help@employmentlawyer.ca. We'll start with that, but there's so much more you can do, and we'll lead into that a little later on the show. On the show today, Lior, you are still owed severance pay if, ... you got to wait for it. We'll cover that in just a little bit. But we always start every show with the week that was. My brother, what's going on with you?
Another busy week, lots of calls, lots of emails, lots of questions about employment law, about workplace rights. It doesn't end, and I don't want it to end because I want to make sure that I get to talk and answer questions and reach as many people as possible. So if you're wondering about your workplace issue, maybe you didn't have the best week. Maybe the boss threatened with losing your job. Maybe there's an ultimatum that you're facing. Ultimatums, by the way, are tricky. Whatever the issue is, give me a call. Let's talk about that. Let's answer your questions. Take advantage of the fact that we want to answer questions. We want to help. So we'll give you my contact information throughout the show today. You can reach out and we can have that private discussion. You can have your questions answered. But right here on the show, we always try to cover a variety of topics about employment law, about workplace rights. But we may not cover yours if we don't reach out privately. But to get us started, week there was. Let me tell you about a situation that came across my desk. I got a call from a lady who about 2 years ago was promoted from an administrative position into a manager role. Came with a pay increase. She was very happy. She found the job really challenging, but as far as she was concerned, she was doing a good job. Well, recently her employer came to her and said, we don't think this managerial role is working out. And because of that, we're going to now demote you back to that administrative role. We don't want to make your life harder, so we're not going to take back the pay increase. We're going to leave your pay as is, but you're not going to be a manager anymore. You're not going to have anyone reporting to you. You're going to be back doing your old administrative role. Of course, she was very upset by that. Who wouldn't be? And she called me. And her question was very simple. Can they do that? Are they allowed to demote me? Now, here's the thing, John. Many may say that, well, they didn't decrease her pay, so maybe that's something that the company is allowed to do. No, absolutely not. Despite the fact that her pay has not been impacted, despite the fact she's not taking a pay cut, this is a demotion. There's a prestige that's being lost. It's going to be a bit embarrassing. It's going to be a big change for her. And because of that, this results in what we call a constructive dismissal. When someone is being demoted, that is not something an employer is allowed to do. And I want you to remember that. Despite the fact that the company owns the business, they're not allowed to demote you. They're not allowed to put you in a position that's a lower level, that's less prestigious, that may even be embarrassing a bit, even if the pay doesn't change. If the company does, you can choose to treat that as a constructive dismissal. In other words, you can say, no, I'm not doing that. Instead, it's as if you have let me go, employer, and you have to pay me severance. Now, for her, she had been there for 7.5 years. She's owed about 9 months of severance, 9 months pay, and she's decided after speaking to me that she would rather do that. She would rather get her severance rather than continue in an environment where everyone knows that she was demoted. If you find yourself in that situation, if you've been demoted, we need to talk about that. We need to talk about constructive dismissal. If your job is changed in another way, your compensation, your hours of work, your work location, if you're facing those changes, you do have rights. You do have recourse. If you're ever in that situation, please call me.
You know, it's interesting, the whole part about the prestige in the workplace makes perfect sense. I get that. It's going to, if she was a manager, look, she's not now. But moving forward, if in the future she goes to apply for another job, I mean, that would reflect, maybe not poorly, but might be a question on her CV saying, okay, you were a manager for a short time and then you lost that job. Why is that?
Well, you're right. She's going to have to answer that in a job interview.
Right.
Why were you a manager only for 2 years? What happened? If the new company finds that she was demoted, they're probably not going to hire her. And so she may say, well, I'm not even going to put the manager role on my resume. I'll just put my administrative role. Well, that's going to make it very difficult to get a managerial position because she doesn't have managerial experience. So there's a lot of different factors here and a lot of different reasons not to accept a demotion because, as John said, it's not just going to impact your job now. It could impact your jobs in the future. So we really need to consider constructive dismissal in those situations.
You can reach out as well by going to employmentlawyer.ca. You'll also find links to our long-running radio show. We've been doing that for almost a decade now on radio across the country. You can tune into a station near you, of course. And we cherry pick some really interesting, good calls from the radio show, play them back here, Lior, and we talk about them. First call for today's show is coming up right now.
My wife was laid off, and she just received this week a notice of termination. She's been employed at this location for 13 years. They have offered her 8 weeks of severance, plus a gratuitous on top of that of $2,500.
John, right there is probably one of the most common calls, common questions, common emails that I get every single day, multiple times a day. I was let go, or my wife, my husband was let go, and they were offered a few weeks' pay. Is that right? So let's break this down. This is a very common situation. Chances are many of our viewers have faced that. So she's been there for 13 years. Her employer is allowed to let her go. It's a question of how much severance is she owed. She was offered 8 weeks plus another $2,500. That's nothing, and that's a lot less than what she's owed. Now, I can tell you right now how much she's owed, but let me show you how you can find out for yourself how much you're owed if you're ever in that situation. pocketemploymentlawyer.ca. Again, let's go to pocketemploymentlawyer.ca and let's plug her information into our severance calculator tool. So she's in a role, let's say a supervisory role. We know she's been there for 13 years. She was offered 8 weeks plus another $2,500. As you can see on our severance calculator at pocketemploymentlawyer.ca, she's owed as much as 16 months' pay. 16 months' pay. That's going to be a difference of tens of thousands of dollars. And right there, is exactly what I have to tell many people that call me, most people that call me. Yes, you know what you've been offered? That's pennies on the dollar. You're offered $10,000, you're owed $60,000. That's why it's so important to go to pocketemploymentlawyer.ca so that you don't get taken advantage of, so that you get what you're legally owed. For her, that meant 16 months' pay, not 8 weeks.
You know, if anybody else kind of walked up to her and said, you know, you're getting paid 1/8 of what you should be getting for severance, she'd look at them like they were crazy. They would never believe her.
Or they would think this is a really unique, crazy situation, maybe something that never happens.
Yeah.
But John, the problem with that, as crazy as it sounds, it happens to most people. 90% of people, when they are let go, are exactly in that situation where they're offered a third, a fifth, a tenth of what they're owed. That's why we're here. And that's why I keep saying, and I've been saying it for years, and I'll keep saying it for years. If you lost your job, you call me. No exceptions, always.
That's on the bottom of the screen all the time, but just in case, 1-855-821-5900. Yet another way to reach out to Lior, terminationquestions.com. It's just exactly what it is. Go to the website, you can ask your questions, and a member of Lior or his team will answer them with a nice, full, and unique answer, tailor-made for you and your question. Want to get one, Lior? First one for today from our friend Christine says, I was hired to a 2-year contract that ran out a few months ago. I was told that I will be kept in the job until they can determine if they still need me. I'm worried about the fact that I no longer have a contract. Should I ask to sign another one? No. No.
Yeah, you see, John, with pantomime, they're giving you the answer. So let me verbalize that. No, the answer is absolutely not. As an employee, you don't want a signed contract. You don't want a written contract. That email agreement, that handshake, that something on the back of a napkin over at Tim Hortons, that's good enough. Okay? That's all you really need. You don't need something that's a 5 or 10 or 12-page document. Now, for her, she was on a contract, a written contract. That contract ended. She continued working. What that means for her now, she's employed under an oral employment agreement. That's good. That means she now has the full protection of the law. So if she's let go, she's owed full severance. That means her employer can't lay her off temporarily. That means her employer can't change her job duties. That means she doesn't have any non-compete obligations. All the good things that the law provides are available to her because she does not have a written employment agreement. So no, she should not ask for one. And same with you. If you're working and you're worried, my God, I want to have this 10-page document. Why can't I get one to sign? Please don't. I get that asked often. You are not interested in having a signed employment agreement. An employment agreement, a written one, helps the employer. It takes rights that you would otherwise have, and it gives it to the company.
Hypothetically, though, if she continued working, as she says she had that one-year agreement, she had the contract. Now she works for another 2 years and they let her go. Is her severance based from the contract onward, or does it include the whole year that she was also on the contract?
It absolutely includes both the first year, because it includes all time employed. So the fact that she spent 1 year under a written contract and then a couple more under an oral contract doesn't matter. She is now a 3-year employee.
Beautiful.
And if she is let go, she gets paid severance as a 3-year employee. And because she doesn't have a written employment agreement, that means she gets the full entitlements, the maximum entitlements under the law, because there's nothing limiting her.
You are still owed severance if. We will get to that, but first we'll take a short break. In the meantime, reaching out, help at employmentlawyer.ca and 1-855-821-5900. This is the Employment Law Show. Stick around. We're coming right back. Think their employer can make changes to their job. Employmentlawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. Employmentlawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at employmentlawyer.ca. Welcome back. Employment Law Show. John Scholes here. Lior Samfiru there. And thanks for sticking around through the break. 1-855-821-5900. Anytime you want to reach out to Lior and the rest of the team members at the firm. Want to talk about this, Lior. You are still owed severance if, these are important points, because a lot of people would say, I had no idea that was true, right?
The situations that we're going to list and talk about are situations where if you come across them, you may think, it may be easy to think, oh, no, severance wouldn't apply to me. I don't get severance in those situations, except they're false. So I want to point out those situations and explain to you not only why you get severance, but also potentially how much severance you get.
Okay, so number one is this. You have been incorrectly labeled as a contractor or an independent contractor.
A very, very common situation. We call that being misclassified. Happens all the time. In fact, majority of people that believe that they're an independent contractor truly, in the eyes of the law, are considered employees. If you have a regular job, if you go to work every day, if you've been doing this for a while consistently, the law is going to consider you to be an employee. And that's important for many reasons. That's important because you should be getting overtime and vacation pay and holiday pay. But it's also important that you're owed severance in those situations if you lose your job. And remember, severance can be as much as 24 months' pay. So if you lost your job, even if you believe you're an independent contractor, you're still likely an employee, therefore owed severance. But it's even more interesting than that. Many people are contractors and still get severance. There's a category between employee and an independent contractor, somewhere in the middle, and we call that a dependent contractor. A dependent contractor is someone that's not an employee, they are a contractor, but because they do the majority of their work for one company, they're financially dependent on that company. So if that company lets them go, they have to get paid full severance. So employees get severance even if you're misclassified, and even contractors in many, many cases get severance. So yeah, don't assume just because you're calling yourself an independent contractor that you're not owed severance. Likely the opposite is true.
If you fall into the dependent contractor category and you're financially dependent on one client, what's the threshold, say percentage? How much of your income depends on them to allow you to get severance?
Usually once more than half of your income comes from one company, you're considered financially dependent. Because if you think about it, if half my income is from one company, if they let me go, that could be, financially disastrous.
Sure.
That's why the law says, well, wait a second, we're going to help you out by making that company pay you severance because we understand that financial impact. So half usually is that threshold.
Point number two, you are still owed severance if you work for a small business, a mom and pop shop, maybe with only a few employees, right?
There's a huge misconception, one that I've been dealing with for years and years, applies in every province, and that is, well, no. Severance is a creature only left for large companies. It's only an obligation that large companies have. I work for a small company, mom and pop shop, 1 or 2 employees. Clearly, they don't have to pay severance. Wrong. False. You are still owed severance if you work for a small company. Not only are you still owed severance, you're owed the same amount of severance as if you were working for a large company. And the reason for that, the factors that go into assessing severance have to do with you. Has nothing to do with the company. The factors are your job, your length of employment, your age, your employability. So nothing to do with the company. So huge misconceptions. I've seen people walk away from tens, if not hundreds of thousands of dollars in severance because they assumed their small employer did not have to pay severance. Size of the payroll doesn't matter. Number of employees does not matter. If you lost your job, you're owed severance. Big company, small company, it's the same thing.
So the math is the same, the matrix is the same, whether it's 2 employees or 2,002. Doesn't matter.
It is exactly the same. Not only do you get severance, you don't get less severance. It's not a situation, well, we'll just pay you a bit less. No, not at all. You could potentially get as much as 2 years' pay, even for a small company. And by the way, pocketemploymentlawyer.ca, our severance calculator tool there, works perfectly accurately for you and any job you have, whether you're in an executive position, in an entry-level position, small company or big company. So check it out for yourself.
You are still owed severance if that's what we're covering the topic on the show this week. And this one is one, again, we get phone calls about this all the time on the radio show. Number one, you're in a federally regulated business or construction. Always.
Always. So people assume, believe, maybe even read somewhere that there's different rules if you're federally regulated or, God forbid, if you're in construction. So let's be very clear. Does not matter. What did I say a minute ago? If you lost your job, you're owed severance. I don't know that I could be any clearer than that. That means if you lost your job working in construction, if you're in a federally regulated company, in trucking or in banking or telecommunications, if you lost your job, you're owed severance. Now, construction here is a big one. There's a huge misconception that those in constructions don't get severance. And why? Well, those in construction may not get overtime in the same way, may not have other entitlements that people have when they're not in construction. But when it comes to your full termination entitlements, they're going to be the same if you're in construction or not. Keep in mind, of course, we're talking non-union position, only non-union. But if you're a non-unionized employee, yes, you are owed severance. Again, potentially as much as 24 months' pay, even if you work in a construction company. And with respect to federally regulated employees, people believe that there's different rules. You get less severance, you get only 2 weeks' pay. Wrong, wrong, wrong. Factors, as always, age, position, length of employment, and a maximum of 24 months' pay.
You still get severance. Point number 4, if you are laid off due to a restructuring or bad performance or the economy, like a pandemic.
Yeah. So right now, a lot of people believe, of course, well, it's COVID-19. I was let go because of the pandemic. I was let go because my company couldn't afford to keep me on.
Right.
And those are legitimate reasons, legitimate concerns. Despite that, the law is the law. And the law says that even in a situation where you're let go because of a pandemic, bad economy, because the company is struggling financially, the company still has the same legal obligations to you when it comes to severance. So let's talk about COVID-19. COVID-19 not only has not eliminated severance, you're in fact owed even more severance if you're let go during COVID-19. And the reason for that is it's probably going to take you longer to find another job. There's more people looking for work, less companies hiring, again, all because of COVID-19. So if it's going to take you longer to find another job now than it would if it was no COVID-19, then you're going to be owed even more severance than usual. So the point here is very, very important. The company may have done nothing wrong. The company may not be picking on you. They may legitimately be letting you go because of COVID-19 or for another business reason. But that does not relieve them of their obligation to pay severance. Remember, severance is not a punishment to the employer. The law doesn't come and say, employer, we're going to punish you by making someone pay severance. Severance is there to help the employee while they transition to another job. So what flows from that is company, big, small, bad economy, good economy, pandemic, or no pandemic. That company has to pay severance, full severance, to the employee that it let go.
You know, a little side note on that whole thing before we get on to the fifth and final point. I know a lot of employers watch the show and they go, man, that's really, really crappy that you put that out there. But you always say that moving forward now, because the pandemic's already here, but next time around, an employer can protect himself in that regard by having an employment contract that lessens the amount of severance, right?
You know, if you think about it, John, oftentimes employers get upset at me. They say, Lior,
Right.
how dare you tell people about what they're owed? First of all, think how absurd that is, right? I don't decide what the law is. I don't go up there and say, the law should be this or that. I'm telling people what the law says. So it's no more, it doesn't make sense to get upset at me any more than it would get a sense to get upset at a doctor saying that you have a medical condition. It's not the doctor's fault.
Right.
But an employer, as you said, can do something about it. An employer is able to enter into an employment agreement with an employee that spells out obligations and reduces obligations. So if an employer does not do that, it can't really complain that it has legal obligations. You have to do things right. If you choose to employ people, if you choose to run a business, you have to comply with the laws. It's as simple as that.
We'll get to one more here. You are owed severance if you were let go due to medical reasons.
So medical reasons. Maybe right now you can't work. You have a medical condition, you're off work, and you're hoping to get better, but the company lets you go. Well, in that situation, even though you're not working right now, even though you're unable to work, yes, you still get severance. Absolutely. You get severance as if you were able to work, as if you were still at work. So, in fact, you could get even more severance if you have a medical condition that impacts your ability to look for work. And potentially, you could also get some human rights damages if you were let go because of your medical condition. So being sick, being unable to work, being let go because of that is illegal and certainly does not deprive you of your severance. If anything, more severance is owed in that situation.
Want to grab another phone call here before we break. Again, employmentlawyer.ca is where you go to find a radio station near you where you can catch the show. And the second phone call, Lior, is coming up now.
I was recently pressured to resign from my position based on a private encrypted chat. Fortunately, the chat did take place during work hours, during downtime, but ultimately they cited me for workplace respect, code of conduct, and social media policies for my resignation. And there was a lot of pressure tactics and duress in order to settle this. I was just wondering if they had grounds to pressure someone to resign.
This is last week. I remember the call.
So first of all, a company never has grounds to pressure someone to resign because the only person that can decide if they want to resign is the individual. By definition, a resignation is something that you, the employee, do unilaterally and voluntarily, not because someone put the proverbial gun to your head and said you have to. So the moment someone says you have to, it's not a resignation. Now, here's the thing. I don't know exactly what this person did on social media, etc. First of all, even if he did something wrong, even if he used the computers in a way that was inappropriate, that does not allow the company to part ways to let him go for cause. Meaning, if the company wants to let him go, they still have to pay him severance unless what he did was awful. He was, doing something illegal. He was, harassing people. Unless he did that, if the company wants him gone, they have to pay him full severance, potentially as much as 2 years' pay. And if you're ever in a situation where your employer says you have no choice but to resign, listen to me right now. You have a choice. You never have to resign. You're the only one that can decide if you want to resign. If the company ever says that to you, your answer is no. I'm going to continue working. If you want to let me go, employer, you can, but you have to pay me my severance. Don't make it easier for the employer to avoid paying you severance by you resigning. Doesn't matter what pressure, the answer is always no. I'm continuing to work until and unless you, employer, decide otherwise.
All right, short break, and when we come back from it, severance for an employee that's been on a layoff after 18 years. We'll get to that on the Employment Law Show. Stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the Employment Lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back, Employment Law Show. Want to get to our third phone call for the show today. Again, EmploymentLawyer.ca is where you'll find a station across the country where you can listen to that show weekly for an entire hour. Phone calls coming up right now, Lior.
Been laid off. I was working there for 18 years, and I was getting ready to send in to ask for my severance. But in the last 3 weeks, my health has deteriorated. Does this change everything? Because I still get the benefits. And because I still get the benefits, they have long-term disability, I believe, on there. Should I not ask for what should I do?
Got it.
So first of all, obviously, being put on a temporary layoff does trigger your right to say, no, I'm not accepting that. I want to be getting my full severance. So a temporary layoff is not something that an employer is allowed to do even because of COVID-19. If you've been laid off temporarily, you can treat that as a termination and get your severance. Now, for this person, right now, he can't work while he's on layoff. He has a medical condition. So the best advice is go on long-term disability, because that could potentially pay you till 65. It could pay you potentially for a longer period of time than your severance. So take that. If you get better, try to get back to work. If they don't take you back, then you're owed severance. So if you find yourself unable to work, you're better off to go on disability if that plan is available to you, because it could pay you until the age of 65. If you're already over 65, of course, disability benefits are of no real value to you in that situation. But if you're under 65, having disability is very valuable. If you're ever denied, you give us a call. Now, as a final thought here, if he did want to get severance, let's go to severancepaycalculator.com or to pocketemploymentlawyer.ca and find out how much severance he's actually owed. So in a technical role, 18 years, let's say he's 55 years old, you can see right at the bottom of the screen that 18 months of severance is what he'd be owed. Same with you. You can go to pocketemploymentlawyer.ca right now to find out how much severance you're owed. If you're curious, if you lost your job, if you're worried about losing your job, pocketemploymentlawyer.ca.
If he ends up on disability through a disability insurer and then he loses his job, the next question everyone asks is, well, is that going to affect my disability? Are they going to cut me off because I lost my job?
Excellent questions. You're on disability, you're receiving disability benefits. Yep. In the meantime, company lets you go. No, the good news is it will not impact your disability benefits. You can stay on disability until either your doctor says you don't need to be on there or you turn 65. The fact that you lost your job does not deprive you or does not prevent you from continuing to get disability benefits. Keep in mind, though, if you are let go while on disability, yes, you're owed severance, but we also want to talk about why you were let go. If the termination of employment had something to do with the disability, that's a human rights violation. That's illegal. A company cannot do that. So we always want to pay close attention to that, but it won't prevent you from continuing to get disability benefits.
And then quickly before we go, he can't just say I'm on a medical leave. He needs medical doctor support to trigger that, right?
Correct, yeah. If you're going to be off on a medical leave, or maybe you need accommodation from your employer, you need modified duties, modified hours, you speak to your doctor, get that doctor's note. That doctor's note is your ammunition. That doctor's note is your shield. It's what protects you, make sure that you have rights, and it prevents your employer from doing anything to you. And it also, of course, helps you deal with your insurance company if you're on disability leave.
We're done. Thank you for sticking around for the 30 minutes. You want to reach out now, 1-855-821-5900. Pocketemploymentlawyer.ca is a beauty. It is absolutely free and anonymous. There's even a section on disability law, which is the other half of Lior's firm. And of course, the email help@employmentlawyer.ca is where we go to all the time. We'll catch you next time in the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.